No one was talking about wanting to be a patent attorney, but I ended up loving it.
How can you share your idea with other people without it getting stolen?
As an attorney, my recommendation will always be,
if you've ever had a great idea and then immediately worried that someone might steal it, this episode's for you. Jessica Hudak, VP of Corporate Counsel at Edwards Lifesciences, is a mechanical engineer turned patent attorney who's mastered the space where invention meets law. We talk about how to really protect your ideas and the wild path that took her from fighter jet engines to mechanical devices. And bonus, Jessica's coming back for a round 2 to answer your questions, so send them in. All right. Well, Jessica, thank you for joining us on the podcast today.
So great to be here. Thanks for having me.
So I've been really excited about talking to you for a couple reasons. One, you have such a really interesting, really neat career arc for what you do. And then second, selfishly, you have so much expertise under your fingertips that I'm excited to ask you some questions about, and I'm really excited for our audience to get to benefit from all of your knowledge.
Sounds awesome. Thank you.
Yeah. I'm wondering if maybe we could kind of start off from the beginning. I'm curious, when you started out in your training for mechanical engineering, if you were picturing this career or a career like this, or how all of this happened?
Yeah, not at all. My family is full of like business folks and artists. And so no one had been an engineer, no one had been a lawyer. And so I didn't really even have those careers on my radar. And so, I happened to be good at math in high school. It's like so good. Well, not so good at it, but I loved it so much that I would like do homework ahead of time in my free time.
Oh my gosh.
I've continued to be a massive nerd throughout my life. Like you'll see that a recurring theme. But anyways, good at math, and just had a few lucky teachers that recommend I think about engineering. And at the time, as you can imagine, the percentage of women in engineering was very low. It's still not great, but it's getting better. But at the time, I entered my engineering class at University of Michigan in mechanical engineering. There were about 20% of us were women. And that was the highest one across the disciplines. It just kind of went down from there for computer science or electrical engineering. So I had a great teacher that recommended I check out engineering. And so I was all in. So I only applied to engineering programs and decided to go to Michigan. I actually grew up in Ann Arbor, right by U of M. And so, agreed to go to in-state college as long as my parents promised if they ran into me on the street, they were not allowed to acknowledge me until I first acknowledged them, like in case I needed to be like cool and not seen by my parents. And they agreed to do that. So, I agreed to go to college in our hometown, but, lived on campus and all that stuff. So anyway, so that's how I got into engineering in the first place. And made it through, really enjoyed mechanical engineering. I still do to this day, obviously, I'm in medical devices and lots of mechanical aspects to that. I liked that you could kind of hold and touch and feel it. There's all of the, esoteric equations and theories and all that stuff. But at the end of the day, you could kind of visualize what was happening. So I like that about mechanical engineering. And the transition to patent law really happened towards the end of my undergrad degree. I took a, intro to IP law for entrepreneurs. And it was taught by Jeffrey Shocks, who's actually kind of gone on to be a fellow biodesign attorney as well, and given lectures and all that stuff for the biodesign group. And I just absolutely loved his class. I would find that I would be, kind of setting my problem sets aside and wanting to read the cases in the law textbook that he had us read for that class. And so loved the class, did well in it. And at the end of that, he said, hey, you did a really good job. Would you be interested? I'm starting my own firm. I could hire you as a patent agent or a patent engineer. And he's like, the only thing is I'm moving to California. And at that time, I had already decided to go to Stanford for grad school in mechanical engineering. And I was like, hey, so am I. So we both ended up in the Bay Area. And so while I was in grad school for mechanical engineering, I worked for him part-time and really kind of learned the fundamentals of patent law. And he's a brilliant attorney and a great teacher. So I feel really lucky that I kind of got a great, strong start to my patent law career through him.
Wow.
Yeah. And so that's kind of how I mechanical engineering, discovered law. And then the last piece was really discovering love for medical devices and wanting to be in that industry. And so I was lucky enough in my summers before, kind of during undergrad and before grad school, I did a bunch of different summer internships. And I got to work as an engineer in a bunch of different technologies. And I had this opportunity to kind of have a back to back experience where I was working on turbo engines for fighter jets for GE aircraft. And then
Wow.
the very next window, I was working for Stryker Instruments and working on their kind of microdrills for surgery. And so I was able to kind of hold those two experiences back to back. And while the engines were so cool, I got to like stand in the test tube where they're, lighted on fire and you're like standing, because they have like layers of concrete and everything. So you can stand really close to the engines and just see all their power. So that was an incredible experience, but I continue to be drawn to the medical device industry. Folks just had kind of like a different skip in their step walking around the hallway. Like there was a different passion in the room for the work that everyone was doing. And everyone was kind of unified around this. We're helping people, we're making a difference. We're doing good in the world. And so I love that. And that actually guided my master's program, and why I chose Stanford, because even at the time was really well known for medical devices, medical device industry,
Mm.
and actually found the biodesign program within kind of a few months of arriving on campus. And I was like, oh my God, this is exactly what I've got to do. So that's kind of how those pieces came together: mechanical engineering, medical device industry, and kind of kicking off for patent law. So that's the beginning.
Wow. What an amazing arc. And it's so incredible how that one person in your life can kind of bend things in a unexpected unexpected journey sometimes. I'm curious, how did you describe biodesign to people when you were hearing about it? I mean, it's this thing that kind of if you know, you know, and everyone kind of gets it. But how were you explaining it to people in your life who hadn't heard of biodesign?
Yeah. And so the other thing I kind of discovered while I was doing engineering early on was that I loved kind of the early innovation stage. And that's what I think drew me to patent laws, because you're just, you're working with inventors at the very beginnings of these, great inventions. Whereas when I was at GE Aircraft, for example, I was designing the arc on a single blade that would be in an, like you're just doing such iterative work at that point. Of course, I was super junior. They're not going to put me on anything interesting, but it kind of helped me appreciate that I like being at the early stages of innovation. So when I heard about the biodesign program, and they essentially teach you how to be at the early stages of innovation and be a successful, medical device entrepreneur, and this kind of multidisciplinary way of teaching, which is, as you can kind of see from my engineering and law, I was already super into this kind of mix of disciplines. I'd also taken a few product design classes or kind of design thinking classes at Stanford. That was even before the kind of design institute was open, but had an opportunity to take classes with David Kelly, who's a renowned designer and been at Stanford for a long time. And so it was bringing in kind of the design aspects of it. And so again, the biodesign program was this like melding of all my interests. And so to answer your question specifically, when describing it, I think I would just say, it's basically a year to learn how to do this thing that seems really cool, like learning how to be a successful engineer. And I love process. I love following directions. My husband makes fun of me. Like I can't cook a recipe without like precisely measuring everything and like following all the steps. Meanwhile, he's just, like throwing ingredients in the pot. So I love a process. I love following instructions. I love step-by-step kind of logical steps. And so the idea that you could take something so abstract around, let's start a medical device company or let's invent a medical device, and turn it into a process that was repeatable. I just love that.
Yeah, well, that's really neat, and I can totally relate. I know there's another 20 years or so, or a little less than 20 years between that experience and all the things you're doing now. I'm curious how you found your path through everything that you've been doing, through starting your own firm, uh, now VP at Edwards. I'm curious what led you in that direction, and if there was um, a theme that was pulling you, or lots of little adventures that were tugging you sort of in the pathway along the way.
Yeah, totally. So the kind of kicking off point, um, I actually took a year off of grad school to do the biodesign fellowship. And so I had to go back and finish grad school. I had no business applying when I did. Like I was a baby. I was like my early 20s. Like I hadn't even finished my master's degree, but God bless them. They let me do it. And it was an incredible experience. Was finishing my master's degree, was still working, with Jeff Shops on his patent firm. And so that was really kind of a fork in the road situation for me is, biodesign could set me up to be this incredible, entrepreneur. I could, start a company or join one of the strategics and kind of learn best practices, or I could really, pursue this law thing and go in that direction. And I decided to do the law thing. It felt like, I don't know. And maybe it was because, during the biodesign program, there's 8 of us. At the time, there were 2 teams of 4. And then, you're in Stanford where all these engineers and designers are kind of thinking about starting companies. No one was talking about wanting to be a patent attorney. And so it felt like I had this kind of unique skill set and like maybe that's where I could make a difference and be successful. So decided to go that route. I remember telling Mike Gertner, who was really involved in the program back when I did it. For folks who don't know him, he's also an incredible, really successful medical device entrepreneur, a physician by training, and a great guy. Google him if you haven't met him, but great guy. So I remember I remember telling Mike Gertner, I'm going to go be a patent attorney. That's what I'm going to do. And Mike was like, what? We don't become patent attorneys. We hire patent attorneys. Like, what are you doing? And I was like, Mike, I'm going to do this. It's going to be great. And it took folks a few years to kind of, what is she doing? Like, no one's done this before. I don't think anyone has since. Like, it's a very alternative path, but I knew it was going to be okay, maybe 3 or 4 years later when Dr. Yak was, giving a speech either around the, for folks who don't know, Dr. Paul Yak's founder of the biodesign program and an incredible entrepreneur himself as well. He was giving a speech around the biodesign graduation or, some other event. And kind of, they like to give stats around the program, how many patients have been helped, how many companies have been started. And he said, and we even have 1 attorney. So I was like, okay, I made it. Like they're willing to recognize that this could be a career path. So anyway, so I decided to follow that path. And so typically at that point, you go to law school next, right? Like if you're going to be an attorney, you go to law school next. Took the SATs, got all ready to do that. But I was like, okay, wait a minute. Like I've already done a lot of school. I've done the fellowship program. What if I want to stay being an engineer? I don't want to have gone through law school. So something that's super cool about patent law is you can actually practice patent law as an engineer or scientist. As long as you have some sort of technical or scientific background, you can take an exam. We call it the patent bar, but you take an exam with the United States Patent Office. And if you pass it, you get your license to practice within the patent office. So basically, all of the back and forth with the examiner, you submit your application, they tell you why it's not patentable, and you kind of do that back and forth. That process is called patent prosecution, and you're allowed to do that without a law degree. You can't go on and do, patent litigation or anything else, but you can practice this area of law. And I loved that area of law because that's what kept me close to the engineers and the inventors and the inventions. So I was like, okay, I'm going to go try this thing out for a while, be a patent agent. And then, if I like it, I'll, do law school in the future. So that's what I did and continued to work with Jeff Shocks for a while at his firm. And then was kind of really missing medical device industry. And so it ended up moving in-house for a company called Buxano. It was a spinal surgery company. It was acquired at some point. I'm forgetting who, but anyway, so one of the Bay Area medical device startups. So worked in house for them as a patent agent, and then as I had done both law firm, I worked at Shea Glenn for a while. Shea Glenn's another great patent law firm focused on medical devices. Incredible attorneys there, friends of Biodesign also. So I had these great law firm experiences. And then I had the in-house experience kind of seeing how companies are interacting with their patent attorneys on the outside. And I saw a lot of room for improvement. I almost kind of took my career through this little biodesign process, right? Like what are the unmet needs in this patent prosecution industry, right? And I noticed that sometimes none of the attorneys I've mentioned so far, but sometimes like attorneys would just like throw office actions over the fence. Like they would just say, oh, you got this, response from the patent office. And as an in-house attorney, or most often an in-house engineer, right? Because it's typically one of the engineers or the CTO that's tasked with managing the patent portfolio before the company is large enough to justify hiring an in-house attorney. By the way, as an aside, I would recommend waiting as long as possible before you bring attorneys in-house. That's like a great area to just send it outside. So, entrepreneurs out there starting companies, don't hire attorneys. So realize that, that's not helpful. They've got 16 other things they're trying to do that day. I wanted folks to like give me a rundown of what they saw, give me the recommendation, kind of give me the key things to look at so that I could go through that. I wanted more proactive management of the portfolio and thinking more strategically across the portfolio, like making sure that the claims we're getting, not only when we file them, but then amending them through prosecution, that they're actually reading on the device that we're trying to build and take through clinic and ultimately sell. Because as we all know, the device changes a lot, right? You learn a lot over that process. And also making sure we're thinking about what our competitors are doing. And so that kind of inspired me to start my own thing. So I started my own patent consulting group and did that for about 4 years. By kind of like at the peak, I had about 3 patent agents working for me, and we worked almost exclusively with medical device companies and pretty much primarily in the Bay Area. And I think people appreciated we took a different approach. We served more as part-time in-house counsel and a partner to the engineers, the CEO, CTO, as opposed to kind of someone sitting on the outside just throwing stuff at you. And so it was really successful and it was really enjoyable, and it allowed me to go from working in-house at one medical device company to helping a dozen at a time. So that was really cool, and I got to see a lot of different companies and how they were working and their patent portfolio and thinking about patent strategy. And for a few of them, I would even come into the office, be there a couple days a week, or my colleagues would. So that was great. And kind of partway through that, I decided to go to law school because I'd kind of been like, okay, I like this. I'd also felt like I'd kind of gone as much as I could, kind of high in my career without a law degree in the law direction. And so I ended up going to law school and kind of ran that company part-time while I was in law school also.
Oh my gosh.
Yeah, it was a lot. I also had a 3-month-old when I started law school. So yeah, it was a wild time. My husband and I joke, we like have no memories of it. My poor daughter, who's now 12, who was the 3-month-old when I started law school, the typical questions, Mom, when did I start walking? Or what was my first word? And my husband and I were like, we don't know. I'm sorry. It's all just like a blank. We're lucky we survived because we had a 2-year-old and a 3-month-old. I was running my own business. I was in law school full time at Stanford. My husband had a big job. But we did it. It was great. It was, the Silicon Valley dream.
Wow. Wow. What an adventure. And then you went to law school and did even more impressive stuff after. And it seems like you're doing, I don't want to say more traditional, but I think when people imagine, someone who does work in IP, this is, I feel like one of the more traditional things that they might imagine is sort of the pinnacle of what someone could hope to do.
Yeah, totally. Yeah, I always joke when folks ask me about it, I did my career backwards. I started in-house, started with my own company, and then went to law school. And then I kind of followed the very traditional kind of law school to law firm path up until, joining Edwards. But as I mentioned earlier, there's patent prosecution, right, which is the back and forth kind of negotiation to get a patent with a patent office. There's also patent litigation, which, if one company or another is infringing another's patent, you can then bring, infringement claims to district court and sue a competitor or what have you. But you can't do patent litigation without a law degree. But I had no intention, going into law school. I was like, okay, I have a really successful career. If I hate law school, because a lot of people hate law school, and I was like, if I hate law school, I just stop. Like, I don't have to do it. I've had a great career. This is great. But I ended up loving it. I loved the reading. I loved the writing. I loved thinking through cases. Like, I loved it. I think too, like being an adult, right? Like I was about a decade older than my classmates. Having had, kind of a first half of a career, or, first third of a career, whatever it is, I had great perspective on, kind of what was important, what I cared about, what I needed to know. And I think that made law school a little easier. And I also knew I was going to focus on intellectual property law. So I kind of knew how to choose my courses and all that stuff. But of course, in law school, you get exposed to all types of law. And, there was a moment where I was like, okay, babe, talking to my husband, I'm going to be a public defender. And he's like, oh God, no, like we can't spend all this money on law school and your career. And then you're going to go, make no money and, being defended. But I think a lot of students have that moment in law school where you realize like, wow, I could do really good. Like there are people that really need lawyers. I've managed to kind of do that in pro bono or volunteer efforts going forward. But anyway, so focused on patent law. I knew I was focused there. But my love of law school and the law, I think, developed an interest in doing litigation. Law school is very litigation focused. You're reading cases, you're writing arguments, which are really kind of the building blocks to having a successful litigation career. It's much less common that you're learning how to write patents or write contracts. All of the kind of transactional work you really kind of pick up after law school. So law school is very litigation focused, fell in love with that. I also then was like, okay, if I'm going to do this litigation career, how does this happen? Like, what does this look like? And so the next step was to clerk for a judge. And so I applied to clerk, and I only applied at the Federal Circuit, which is the U.S. Court of Appeals that hears all of the patent appeals. Sometimes folks misunderstand that the Federal Circuit is the patent court, but we actually have a really cool range of cases that we hear. We hear government takings cases. Your audience probably has heard about Trump's tariff case. That actually is at the Federal Circuit because that came through the International Trade Court, which was another site. We also got government contracts, but I would say like 80 to 90% of the cases we worked on were patent cases, which was fantastic. It's exactly that. So applied to clerk at the court, was lucky enough to get offers and, accepted to work for the chief judge at the time. Her name's Sharon Prost, Chief Judge Sharon Prost. She's now still a judge of the court, but the chief title kind of cycles through every 8 years. They kind of move it through the judges. But she was chief while I was there. And honestly, I think that was one of my favorite career experiences. My husband and I decided to pick up our two kids, move to Washington, D.C. for 2 years, and we wanted to have that experience. So we lived right in the city, kind of on the outskirts of the city where folks who had kids lived, had our kids in public school there. And then I got to work at the court, and you could actually see the White House from my office. You could see the Washington Monument. So we were just in the heart of D.C., and it was amazing. I love living in that city. I love that job. It was incredible. Your job as a clerk is to prepare the judge. And so you read all the briefs that come in, you read all the cases, you write a memo for the judge, kind of here's what the cases say, here's what a recommendation could be. You then talk through through the case with the judge, which is incredible. Just getting to speak with these brilliant, legal scholars. And then if it's the judge's opportunity to write the opinion, you help write the opinion. So you draft parts of it for them to review. And I remember the first time I, helped write an opinion, and it was actually kind of a big deal. We were holding a provision in a veterans case, which is another set of cases we got unconstitutional. It's kind of a big deal for, a young lawyer's first opinion out there. And I remember like telling the office that they could publish it and then just like panicking, like being in a cold sweat. Like I have no business like writing opinions that are out there becoming law. And I remember, like desperately reading the legal blogs, like what are folks saying about it? Da, 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 da. So that anyway. So and then that just goes on from there. It's just an incredible experience. And then that wrapped up about 18 months later. And this is when I kind of get on the traditional big law path. I interviewed with all kind of the big law firms. But we knew at this time, I was expecting my third kid. And so my husband and I, we knew we didn't want to go back to the Bay Area. We'd kind of like been there, done that, experienced that. And actually getting out of the Bay Area and living in Washington, D.C., we were both like, oh, there's other great places to live. Like we were just like so Silicon Valley focused at the time. And so we considered a few places to live, staying in D.C., moving, wherever, and it ultimately ended up on Southern California in Orange County. My parents had moved there a few years earlier. My brother and sister are down here as well. And so expecting our third kid and going into a big law firm, which is just notoriously terrible hours, we're like, okay, we need family help. So that got us to Southern California. So applied to kind of law firms in the area and ended up joining a firm called Gibson Dunn, which is just an incredible firm with just brilliant attorneys. And every moment I spent there, learning from these incredible attorneys and working alongside. was amazing. And so when I was at Gibson Dunn, I focused on patents, intellectual property in general. I did trade secrets, patents, and a few other things. I developed an interest and skill for kind of more appellate litigation, I think kind of building off of my time working for a judge. And so appellate litigation is kind of, everyone knows what trials look like, right? That's what they show you on TV with lawyers, arguing from the judge, interviewing witnesses and all that stuff. But if you win or lose there, then you appeal up to, if it's a patent case, up to the Federal Circuit where I worked, and then up to the Supreme Court. And so I focused in that kind of appellate area. And what I loved about it, again, was reading cases, writing arguments, kind of the deeper thinking. My favorite thing is if I wasn't alone in my office, just writing for a whole day, I was happy. And I even, while I was at Gibson Dunn, had the opportunity to work on a case that was in the Supreme Court. It was a patent case, somewhat well known, called Arthrex. And the argument in that case was, interestingly, in the last, in 2012, the Patent Office kind of beefed up its judicial branch within the Patent Office, or kind of judicial body. So you can actually argue to invalidate patents within the Patent Office. And so the question we worked on in our Supreme Court case was whether or not the director of the Patent Office was constitutionally appointed or not, given the power, and whether there was enough oversight over that director. So just like really fun, really interesting constitutional issues. And then as that case was wrapping up, we'd hit, COVID, we were all in the lockdown. And I remember realizing, because I was working from home, I was home with my kids, 3 kids at the time. My husband was home. I was like, oh, hey, I like you guys. Like, you're cool. I would love to be home when you were all awake. And so it's like, okay, I need to find, a different job. And again, it's not Gibson's fault. It's not Big Law's fault. I think I was laughing with a friend the other day. I have the worst personality for Big Law because I just want to do well. I want to say yes. And I want to do go above and beyond. And so that if you do that in a law firm, you are going to always work. There will never be. I learned how to set boundaries with myself, which I'm trying to be figuring out as I get older. But anyway, so I was ready to start looking for a career switch. And being in Orange County in Southern California, the biggest, best medical device company down here is Edwards Lifesciences. So I knew I wanted to get in there. I knew I wanted to get back to the medical device industry. I felt like at Gibson, although I had these incredible legal experiences, we were essentially figuring out what the law should be on these novel issues that had never been decided. But at the end of the day, it felt like I was just helping rich companies move money around. Like, that's kind of what patent litigation is, right? Like, if you infringe your patent, you have to pay a lot of money. And so I wanted to get back to kind of the core, like where my heart was, and that's in the medical device industry. And so luckily, knew a few folks from the Biodesign program who'd also made the jump into Edwards, and you start calling around and chatting with them. And everyone was just so positive on the company, and it has this really great patient-focused culture, just a neat company, and innovation is so important. Like, if you look at a list of our peer companies, we are spending way more on R&D and kind of investing back in new products than anyone else out there. And as a patent attorney, I love that, right? Like, I knew there would be a lot of cool inventions coming out, a lot of cool patents. And so lucked out to find a job there. And it's funny, like, I couldn't be doing, like, going from appellate litigation to being a business lawyer is about as different as you can get. Like, I was nothing at Gibson Dunn, like, really taught me to how to be a lawyer at Edwards. And so I, with a lot of learning on my feet, I felt like I was drinking from a fire hose for probably like the first 2 years I was there. And my job is really interesting at Edwards because, I still get to practice law. I'm an IP attorney, especially because I work within our advanced tech business unit where we're developing kind of all of our pipeline products, also looking externally to invest in and acquire startup companies to bring that technology in. So I get to work on patent law all the time. But I also get to be a business partner, and I sit on the leadership teams, and I kind of help the business and think about risks that could be coming down the path. And I've gotten to spread my kind of work to not just patent law, but regulatory law, reimbursement, contracts, employment, so kind of all of the above, which has been great. And I always owe it back to the Biodesign Fellowship, because at an early point in my career, I was exposed to the entire process, right? From conception to commercialization. And so clearly you need to understand along the way the regulatory pathways, reimbursement strategies, all that stuff. And so it's really been feeling like a full circle moment that I get to come back and kind of be a business partner in advising in these areas with respect to kind of the legal issues that we might face. And so that's where I ended up. And I've been here the last 4 years, and it's been incredible.
Wow, what an incredible journey. This is amazing. I'd love to shift gears slightly and ask you some questions that may bring you back to your biodesign days in terms of the sort of early approach from folks who are really at the beginning and starting to wrestle with some of these legal questions. One question that maybe the most common question that I think people ask themselves at the very beginning when they have an idea or they have an idea plus they think they're onto something is, how do they talk about it? How can you share your idea with other people without it getting stolen? And I'm curious what you tell someone who's really worried about that.
Yeah, absolutely. So, I mean, as an attorney, my recommendation will always be file a provisional application as soon as possible, because unless you've somehow protected your invention, there really is no guarantee that someone won't steal it or steal the idea and build on it. And so, before you go out into the world, either whether it's trying to raise money or even just, talking to physicians, hey, could this work? Could this be a thing? You really want to, once you've started conceiving and reducing to practice your inventions, your solutions, start getting them into patent applications. Engineers, scientists, whomever is kind of doing the inventing can write the provisionals on their own. And there's resources out there like, how do I write a provisional, and then file them. And actually, the patent office, the fee is only $65 to file a provisional application if you're a micro entity. There's qualifications that basically like very few employees making less than a certain amount of money, and so $65 in order to protect your invention that could be worth 650 million someday is certainly worth it. And then the other thing for folks to keep in mind, two other things I'll say is, one, in 2012, I was talking about that law change earlier. That was the American Invents Act. We changed to a first to file system. We'd always previously in the US been a first to invent system. So you could have invented something, first, and then maybe 3 other people invented it. And then you could file your patent application after them and you would still get it. So that was first to invent. We changed to a first to file system, and that actually brought us in line with all the other countries who were a first to file. And meaning, even if you invented it first, if you didn't get to the patent office first, you wouldn't get the patent on it. And so that's another reason to file provisional applications early, because you don't want someone, who's maybe working across the country simultaneously inventing to get to the patent office first. And it may sound impossible that such a scenario could happen, but the CRISPR technology, that's actually a perfect example of where 2 labs were conducting research and kind of inventing simultaneously. And so they've, had battles in the patent court over who gets what. But actually, the case came up through the federal circuit while I was there. So that was super cool. And so, so that's reason number 1 is first to file. So you want to get your filing on early. And also, medical devices, as I alluded to earlier, they change a lot, right? As you do your bench testing and then your early animal testing and then your, first in human testing, you're going to learn a lot. You're going to change a lot. And as you have these device iterations over time, I encourage folks to thinking about, okay, is there an invention here? Did we invent something new to solve a problem we saw on the bench or whatever? Get another provisional in at that point. You can, as folks probably know, you need to convert provisional applications to what we call utility patent applications within 12 months. And so what I recommend doing is, every time you have an invention, getting a quick provisional out there, and then you can roll them all up into one at 12 months or kind of make other decisions with your patent attorney around strategy. But err on the side of filing early and of filing often is kind of general advice there. And then the last thing I'll say is kind of a watch out is that we do have a rule where if you have been, offering for sale, if you've been disclosing your invention, if you've been out talking about it, if you don't file a patent application within a year of that kind of first disclosure, public disclosure, you won't be able to get a patent on it. And so even if you're the first to file, first to invent, you file it. If you've been talking about it for more than a year, you won't be able to get a patent. The idea is you kind of put it into the public domain at that point. And so certainly you want to make sure you're filing before before you're disclosing it. And a thing for our industry folks to watch out for is medical journal articles are prior art against patents. So if a scientist puts out a journal article on what they're working on, that will count as a public disclosure and could impact your patent rights. So anyway, that's to answer your question. And so, as I was thinking about this, there really is no way to talk about your invention without, there are no guarantees, right? Like someone could steal it. And so you've got to do your work beforehand.
That's incredibly helpful. Thank you. You mentioned something there that kind of dovetails with another question that I think people may ask themselves at this stage. You had said, is there an invention here? And I think people often ask themselves when they're working with AI or they have an AI-driven idea, can they protect that? Is that something eligible to get a patent? And how should they think about protecting their AI idea?
Yeah, absolutely. So there's two ways to think about this, or kind of two categories of AI and inventions. There's inventions to improving AI, whether it's training methods or data sets or what have you, a way of kind of improving the responses you're getting back. So that's inventions around kind of AI technology. So that's one bucket. The other bucket, which I think is more kind of along the lines of what you're referring to, is using AI as a tool and to help create inventions or to help innovate or get to conception. So let's start with that one. And so the Federal Circuit in the last few years decided that no, AIs can't be inventors. You cannot list an AI as an inventor on the patent. It has to be human. And that's based in kind of how our law is written. And interestingly, I was reading an article the other day that kind of a survey of 17 different countries across the world. All of them agree there needs to be a human inventor involved, except South Africa. Interestingly enough, an AI can be listed as an inventor there. So there has to be a human involved. And then that's really just where you get to kind of a test for inventorship anyway. As we all know, in our industry, there's often brainstorming sessions, collaborations, typically more than one person inventing, in our space. And so anytime you're trying to determine who an inventor is and whether or not to add that person's name to the patent, they need to have made a significant contribution to the conception. And so it needs to be kind of a meaningful invention in order for that inventor to be listed. And the same test pretty much applies whether you're comparing that inventor to another human inventor or you're comparing that inventor to AI. It wouldn't be enough simply to enter a single prompt and then try to patent what the AI came out with. There needs to be more involvement there. But the court has said, and kind of the patent office guidance that has come out, it could be just putting prompts in, but they need to be kind of varied and technically challenging. There needs to be more than just invent a new chair for me. Like you need to have kind of done more in the prompt and kind of thinking through that. And so in general, there was a lot of hullabaloo around all of that and that case decision. I think just because AI is so new and we're all trying to kind of figure out the angles around it. I think it's, pretty straightforward. And I think more often than not, even AI is a tool, just like, our keyboards and our computers and all that stuff. And as long as there's human involvement, that human can be listed as an inventor and go on. So I don't worry too much about that. I think we will most often see, significant human contribution. And so be able to patent inventions where you've used AI as a tool. I'll just speak really quickly on that first bucket where you're making technical improvements to AI. You may be familiar with Section 101, kind of patent eligibility, and kind of starting back in 2014, there was a big case called Alice, and that determined, software has questionable patent eligibility. Algorithms have questionable patent eligibility. And really what the cases early on were dealing with is, maybe, I don't know how old you are, I don't know if you're around, but kind of like in the first dot-com boom, folks were taking businesses that existed offline and just bringing them online, like selling dog food, but doing it online, or, collecting personal data, but doing it online. And so the court really, decided to crack down on that. And so activities that were previously done by hand, but then moved on to a computer, you can't patent those, right? Because that kind of existed out in the world. You can't, get a monopoly or a, exclusive right to enforce just because you decided to put this existing activity on a computer. And so AI is different, as you can imagine. That is a very complex technical problem. And they're, as we know from kind of the bloopers we see from AI, they're hard, far from perfect at this point. So there's continual technical improvement going on there. And almost certainly all of those technical improvements will be patentable. But it's kind of the same analysis when you're looking at any algorithm. Is there enough there? It's proving out to be also that this current administration seems to be pro patent owner. They're kind of making it easier to get patents. I mean, it'll be interesting to see kind of how it all plays out, right? We've only had this administration for about 6 months, but they're trying to speak more about patent quality up front. But also, I think, Section 101 software rejections went too far in one direction. So they're trying to bring that back so you really can get patents on patent eligible subject matter. And so, yeah, it seems to be kind of more patent owner friendly. So we will see, which is always good for small companies, entrepreneurs, where if they can get their patents, enforce their patents and not risk losing their patents in the patent office through, post-grant proceedings. So, yeah, so there's your
Wow.
AI question.
Oh, that is very cool. Well, I want to be cognizant of the time. I'll say one final quick question. I hope this is a quick question. Feel free to not answer if it's a long answer. But uh, for folks who are just at the very beginning, who have limited resources and may have a small budget to work with their very first attorney, what would you tell someone is the best bang for their buck? They've already filed their provisional. Maybe they've been filing a bunch and sort of ready to roll up when the time comes. How would you recommend someone spend their first dollars?
Yeah, absolutely. So I think you can kind of use an attorney in a smart area, like you said, whether you'll get your most bang for your buck. That means doing more of the work yourself, but us entrepreneurs, we roll up our sleeves and we get it done, right? We'll wear any hat, whether it's the patent attorney hat, the janitor, or whatever it is. And so the more you as the inventor or, person within this startup company can write and do the research up front, do the patent searching up front, and kind of come to your attorney with a pretty well-written description of what your invention is, maybe some alternative ways of building it, or kind of, you could include this piece in this embodiment, but maybe not here, and kind of really have thought about all of that. And again, there's great tools and resources online for folks kind of thinking about drafting patent applications, thinking about whether or not what they have is novel and non-obvious. And so really bring your attorney, so give them kind of a prepackaged thing so that the attorney can kind of read through it, add here and there, spot any red flags, and the attorney can really focus on crafting claims, because claims are they're the kind of the sentences at the end of the patent. And that's what defines the scope of kind of the invention that the patent office will have given you this exclusive right to for a limited amount of time. So it's those claims that define the scope of what you can prevent other folks from doing. And so those claims are really important. And so having an attorney kind of review your draft for kind of any red flags, and then being able to focus the time on drafting those claims, I think that's money very well spent. Once you get into the prosecution side of things, you can take a first pass at responding. We call it an office action. It's basically when the patent examiner comes back and says, okay, you can't have this because this prior art exists. So that back and forth. So taking a first pass at that and really digging in on the prior art, thinking what your arguments might be. Well, no, we're totally different because we don't do blah, 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 or we do blah, blah, blah. And then kind of doing a first pass and then having an attorney weigh in will, again, be kind of a more cost-effective way to kind of have the attorney be focused on where they're really, really adding value, but then being willing to kind of do that work to get the attorney there. I think it's a good way to work with an attorney early on. But they're important. I think folks hate spending money on legal fees. I know I do, even though I am an attorney, because it doesn't feel, it's one thing to, have a lease or pay, this many $100s for a sheep so you can do your site. Like, you see the value immediately, right? I often joke at my job now, I've done my job well if nothing happens, right? Like, if everything just goes according to plan, I've done my job well. So it's sometimes like hard to wrap your mind around putting money towards these things. But it is money well spent, and you can kind of, try to save some money and time by doing a lot on your own. In our industry, especially, investors really care about patents. They know patents. If you're in a tech industry, that's a whole different story. But in medical devices, patents are important, and investors are going to want to know you understand your patentability position. What can you actually protect? What can you prevent others from doing? and you understand your infringement or potential risk of litigation position. Investors are going to ask about that, so you need to know about that. And that's another area where bringing an attorney in kind of key aspects of that. You can do a lot of the work yourself and then kind of consult with an attorney. But that's another great, bang for your buck.
Oh, that's so helpful. Well, Jessica, thank you so much for your generosity and all of the inspiration that you've shared today.
It's been my pleasure. It's been really fun chatting with you.
Well, same here.